Hello, everybody.
We're on the record in People versus St. Moore, case number 246764. The record should reflect Mr. St. Moore is present here in the courtroom today. If I could have counsel for your appearance.
River appearing on behalf of the people.
Thank you, Your Honor. Richard Trush on behalf of Mr. St. Moore.
This was set for a sentencing hearing today. I am in receipt of a case report from Agent Brunikel, who was the agent assigned to do the pre-sentence report in this case. In that case report, he's outlined a number of attempts to reach Mr. St. Moore for preparation of a pre-sentence report, and indicates that he failed to get cooperation from Mr. St. Moore. So I guess, Mr. Trush, I'd be asking your client to explain why he hasn't cooperated with the pre-sentence process here.
Well, so Your Honor, I think there's a couple things going on. So Mr. Brunikel reached out to me in mid-January asking for contact information for Mr. St. Moore. I provided him with 2 phone numbers that I had for Mr. St. Moore, but I don't think they were accurate numbers. He contacted me last week from a number that's different than the 2 that I had provided to Mr. Brunikel. Mr. St. Moore has indicated to me after he contacted me, I gave him Mr. Brunikel's contact info, told him get in touch with them right away. Even though we're not likely to be able to get a report done, at least making contact is a good thing. He reports that he reached out to Mr. Brunikel, has not heard back from him yet. I spoke to Ms. Davis about that today. I think she's indicated that Mr. Brunikel said he hadn't heard from him yet. But that's the update that I can provide to the court, is at least I think I bear some of the responsibility for not providing Mr. Brunikel with accurate numbers.
Ms. Bruker, do people take any position?
I would defer to Ms. Davis if she doesn't think additional prior to the contacts.
Okay. Ms. Davis, anything additional?
Nothing more than was in the report now.
Okay. All right. First of all, I mean, the phone numbers, I don't think that's your fault, Mr. Trush. Mr. St. Moore, it's up to him to make sure that you have correct numbers for him. I view that, Mr. St. Moore, that's on you for not providing the proper information to your attorney. The pre-sentence report process is a crucial step in the case, one that you're required to comply with. I have no reason to doubt Mr. Brunikel. He's got no reason to make up any of the facts that he put in his report, and no reason to state that you haven't contacted him. In fact, you've been trying to contact him. So at this point, we do need to move forward with sentencing. I think the best way to ensure that is to have you in custody so we know where you're at, we can complete the report. So based on your failure to comply, the court is going to revoke your bond, order that you be taken into custody today. The court will set this for a sentencing hearing at its next available date. And Ms. Davis, if you could just notify Agent Brunikel that Mr. St. Moore will be lodged and contact him at the jail for the pre-sentence report. So, yeah.
When do you want the next hearing scheduled?
We'll set it, Jen will set it for our next available.
Okay.
Yeah. Our next hearing is set for 9:30. We'll take a short recess until that time. On the record is People versus Barber, case number 246767. The record should reflect Mr. Barber's present here in the courtroom today. If I can have the counsel put your appearances on first.
And a burger on behalf of people.
Here at Eagle on behalf of Mr. Barber.
This is the date and time set for a sentencing hearing in this case. Mr. Barber, have you had an opportunity to go through the pre-sentence report and talk to Mr. Kilo about that?
Yes, sir.
Okay. Mr. Kilo, are there any additions, deletions, or corrections to that report?
None, Your Honor. Thank you.
Are there any challenges to the scoring of the guidelines?
No challenges to the scoring.
I do want to state for the record, I received a report from Ms. Van Wolfen from the Community Corrections Pretrial Supervision Program, and I had a chance to review that report as well. Ms. Bruker, do the people have any additions, deletions, or corrections?
No corrections and no challenges to the scoring.
Mr. Gilo, can you move that podium? That way I can't see Ms. Bruker. Set this voice. Here we go. All right. Any challenges to the scoring, Ms. Bruker?
No, Your Honor.
All right. Anything on behalf of the people for allocation today?
Your Honor, the guidelines are 10 to 23, and then DOC is recommending period in the county jail up to 12 months. I would ask the court to follow that recommendation on the basis of defendants' pretty recent incarceration in another county, and the fact that he was defended almost immediately. He was released from that period of incarceration.
Thank you, Mr. Gilo.
Well, I'd ask the court to deviate from the recommendation based on the fact that he has always admitted to a crime that he's committed. He did go to inpatient treatment. I think the court has a copy of that completion. He just completed that, showing that he's serious about taking care of his drug problem. This isn't a delivery charge, it's a simple possession charge. Now, I understand my client's record follows him, and the court has to take that into consideration. But also take into consideration that in all of his crimes that he's committed, he's always admitted to them. He's never taken anything to trial. And like I said, he graduated from the Harbor Hall substance abuse treatment, which indicates to the court, I think, at least to me, that he's taking this seriously. So I respectfully request that the court might consider lesser charge, lesser incarceration than what's recommended. Perhaps maybe 6 months in Otsego County Jail would be appropriate.
Thank you, Mr. Barber. Anything that you wanted to say today?
Yes, Your Honor, that, I didn't take full responsibility for my actions and what I did. And I know I got a drug problem and I am trying to fix it. I'm sorry.
Okay. I did read through the report, so I'm familiar with what happened in this case. I'm also familiar with your past history and your record based on the information in that report. And, I think there's competing factors here that the court has to take into consideration in terms of your sentence. The negatives, of course, are your past record. You've got 8 prior felonies. You've been on probation a number of times, jail a number of times. I think one prior prison sentence. And up until now, at least, none of those things have managed to make an impact to the extent of things. And Ms. Brewer's right. You had some charges that you were recently released from earlier in 2024, and then immediately had this case come up. So those things all give me some pause in terms of your ability to work from this and not reoffend. The positives, when I reviewed the community corrections report, you were in their program for 107 days, so a little over 3.5 months. Ms. Van Wolfen indicates that you were fully compliant with that program, that you followed through with the recommendations that were made by your therapist, that you completed your program in Harbor Hall and then the transition house after that. And even when you were participating in those, you continued to check in and comply with all the requirements of pretrial supervision. And so those things, along with what Mr. Kilo said in terms of your willingness to seek treatment, follow through with that, I think are mitigating factors that provide some indication that you are trying to address this issue and move on. So in terms of balancing those two, number one, I don't find, even though the guidelines could call for a prison sentence, I don't think that that's appropriate. given your efforts to rehabilitate during the pendency of this case, I think that would only set things back for you to the extent that you made progress. But I also don't think there's any reason to go below the guidelines in this case. There aren't any compelling factors that would lead this court to find that based on your past history and your conduct here that that your sentence should be below what the guidelines are. So I think a sentence with a community sanction within the guidelines at the low end addresses your prior history and continuing to reoffend, but also grant you some credit for mitigating factors and for the treatment that you sought during the pendency of this case. So I think it does take into account all of those things. So, and that is what the recommendation is, and I think it's an appropriate recommendation. So the court is going to sentence you to 12 months in the Otsego County Jail. You have credit for 2 days served. Because this is a non-violent crime, non-assaultive crime, because it doesn't involve delivery of methamphetamine, it's a possession charge. And given your efforts at rehabilitation during the pendency of this case, I don't have any objection to your immediate release to work camp. So participation in the work camp program as opposed to jail. That'll be up to the jail force to make sure that you qualify for the program, but I don't have any objection to release to the program. You do have the ability, I'm sorry, the court is also going to impose crime victims assessment of $130, court costs of $300, attorney fees of $325, attorney fees of $350, and a state cost of $68. You do have the ability to seek an appeal of the sentence. Mr. Gila, do you have Mr. Barber?
I do, Judge. What's the date today?
February
6th?
5th.
That's what I thought.
I have court costs is $130.
Yeah, that's it. Can you let me know once Mr. Barber has acknowledged receipt of his appellate right, please?
For the record, my client signed his receipt of I'm handing a copy of it. Whoops, that goes, this goes to the full.
So we got 12 months for simple possession charge. That is unique.
Yeah, no, that's no, his bonds is being revoked.
All right, thanks.
Be safe, be well, sleep sweet, and much love.